The White House is adding more confusion to a proposed freeze on spending related to federal grants. The situation is still evolving, but these are the latest developments. The White House is emphasizing that Trump's executive order about reviewing all government funding remains in place. But on Wednesday, Trump's budget office rescinded a measure implementing a freeze on trillions of federal dollars that flows from Washington to states, schools, and organizations. That move came less than 2 days after the White House Budget Office ordered the financial lifeline halted.
Hello, welcome everyone. Emily is here. So this is happening. A White House press briefing became a significant legal and political event when the press secretary made a social media post that a federal judge later cited as evidence of bad faith, potentially undermining a major legal position the administration was attempting to establish in court.
Well, I think there's only uncertainty in this room amongst the media. There's no uncertainty in this building. So let me provide the certainty and the clarity that all of you need. This is not a blanket pause on federal assistance and grant programs from the Trump administration. Individual assistance, that includes, I'm not naming everything that's included, but just to give you a few examples, Social Security benefits, Medicare benefits, food stamps, welfare benefits, assistance that is going directly to individuals will not be impacted.
The central figure in this situation is Karoline Leavitt, the White House press secretary, the one person whose entire professional role is built on controlling the narrative. Her job is to refine the message, to clarify the administration's position, and to do so without providing material that could harm the administration's legal standing. Yet, in a significant miscalculation, she posted on social media in a way that directly contradicted what the administration's legal team had just told a federal judge. If you are trying to argue right now that CNN's coverage of President Donald Trump is not overwhelmingly negative, I think the American people would tend to agree, and your ratings would tend to support that assessment as well.
California is suing the Trump administration in hopes of unfreezing billions of dollars meant for low-income families.
And they have, without any evidence, shut off billions of dollars worth of funding and hurt millions of people in the process, vulnerable people.
The U.S. Department of Health and Human Services accused 5 Democrat-led states of fraud: California, New York, Colorado, Illinois, and Minnesota. The administration announced a freeze on $10 billion in child care and family assistance funding.
The legal background is a federal courtroom where a significant legal challenge is unfolding. A coalition of 23 state attorneys general has come together to challenge one of the Trump administration's most consequential executive actions, a sweeping freeze on federal grants. This is not a small matter. This involves billions of dollars in appropriated funds that Congress legally allocated. I have 2 questions for you. Regarding Independence Hall in Philadelphia, the administration decided to appeal a judge's ruling that was essentially requiring certain slavery displays to be reinstated, arguing that the federal government believed it had the authority to manage how historical topics are presented at federal sites. The judge said it does not have that authority. The administration said it was planning to put up updated interpretive materials and provide a fuller account of the history of slavery at Independence Hall.
Donald Trump's reckless action cut off funding to law enforcement, farmers, schools, child care, veterans, and health care. While he was out golfing, he threw the country into crisis. It's stupid, buffoonish, childish.
Federal grants and loans reach into virtually every corner of Americans' lives, with hundreds of billions of dollars flowing into education, healthcare, disaster relief, infrastructure, and a host of other initiatives. The judge saying, quote, "It seems like the federal government currently doesn't actually know the full scope of the programs that are going to be subject to the pause." The White House defended the funding freeze, saying it's needed to make sure programs don't run counter to President Trump's agenda.
When the administration froze the funding, the impact was immediate and significant. States were not given a grace period or advance warning. They were simply cut off, left working to figure out how to pay contractors, keep social workers employed, and prevent critical community projects from running out of funding. The legal argument from the states was constitutionally straightforward. You cannot do this unilaterally. The power of the purse belongs to Congress. The legislature appropriates the money, dictates where it goes, and the executive branch has a constitutional duty to execute those directives faithfully. You cannot unilaterally withhold funds simply because you disagree with where they are going. That is a direct challenge to the separation of powers.
I'm also seeing that the press secretary, White House press secretary Karoline Leavitt, is now putting out a message on X saying that is not the case. Do we know what's going on?
Yeah, Kira, we're just learning this moments ago, but the White House is rescinding that order. So I want to really make it clear that this is a very astonishing and remarkable turnaround. This follows a very chaotic 48 hours. This is a complete reversal and walk back. Remember, on Monday, the Trump administration had ordered that federal freeze to ensure that this federal funding was in compliance with Trump's executive orders and policies.
She posted a few sentences on social media, and in doing so, provided a federal judge with evidence that the administration's stated position in court may not have reflected its actual intentions. We are talking about a significant legal situation where the administration's own spokesperson publicly described the strategy in terms that directly contradicted what the legal team had represented to the court. Presiding over this legal dispute is a federal judge who had already been indicating he was not persuaded by what the administration was presenting. Judge McConnell was watching the proceedings, listening to the state's requests for relief, and signaling that he was prepared to issue a temporary restraining order that would require the administration to release the frozen funds immediately. Here is where the situation shifted from a difficult legal challenge into a significantly more serious one. The Trump administration's legal team, recognizing that things were not going well, attempted a legal maneuver. They withdrew the memo that had initiated the freeze. In court, they told the judge essentially that the situation had been resolved, that they had reversed course, that the freeze was being lifted, and that there was nothing remaining for the court to adjudicate. This was a calculated attempt to render the case moot, to remove the basis for the state's claims by appearing to comply just enough to avoid a formal court order. For a brief period, the legal team appeared to believe this approach might work. But then Karoline Leavitt made a post on social media. She apparently wanted to reassure supporters that the administration was not truly reversing course. So she posted essentially that the withdrawal of the memo was not a cancellation of the federal funding freeze, and that the freeze remained in effect and would be enforced regardless of what paperwork had just been pulled back. Judge McConnell saw the post. Federal judges and their clerks monitor the public statements of litigants appearing before them. When the judge read those words, the administration's legal position changed dramatically. He read the administration's official spokesperson, confirming in public that the reversal was not genuine. The judge concluded that the administration was telling him one thing in court, while its spokesperson was telling the entire public the opposite. This was the foundation for a finding of bad faith. This was not a minor communication error. It directly undermined the administration's credibility with the court. The judge cited Leavitt's social media post as a primary reason why he had to intervene with a formal court order. He found that her statement revealed what he described as a distinction without a difference, meaning the administration was using different language but pursuing the same conduct. The administration was not genuinely complying. They were attempting to continue the freeze through other means, and Leavitt had publicly confirmed exactly that. The judge made clear that because of this disclosure, the court could no longer rely on the administration's representations in court. When the significance of what she had done became apparent, Leavitt reportedly reacted with considerable frustration. According to reports, she is attributing blame to others rather than accepting responsibility. She is criticizing the judge. She is criticizing the media for reporting on her own words. She is criticizing the state attorneys general. This response suggests a significant difficulty in accepting accountability for the consequences of her own public statement. The practical consequences for the administration are substantial. Because of the bad faith evidence she provided, the judge is now moving toward the most comprehensive version of a restraining order available. The administration is facing a court mandate that will require them to release the frozen funds immediately. And the situation extends beyond simply releasing the money. Because the judge now views the administration as having acted in bad faith, he is likely to impose ongoing monitoring requirements, potentially including regular reports, audits, and sworn documentation to demonstrate compliance. If the administration delays compliance with any of those requirements, it faces contempt of court proceedings, significant fines, and a constitutional challenge that would be far more serious than the current one. The administration's legal team is reportedly in a very difficult position, dealing with the consequences of having their credibility with the court significantly damaged. In the legal world, credibility with the judiciary is essential. Attorneys build that credibility over time. Leavitt's post raised serious questions about the reliability of the administration's representations to the court, and that affects not just this case, but the administration's standing in every other ongoing legal matter. Every judge reviewing administration filings may now consider this episode as relevant context. The legal strategy that was attempted was relatively straightforward. When you are in litigation and facing an unfavorable outcome, you can demonstrate voluntary cessation, meaning you stop the conduct at issue. You tell the court you have stopped, so there is no need for a formal order. If done genuinely, this can render a case moot. The administration withdrew the memo as step one of this approach. But to make it work, the conduct actually has to stop. You cannot have your spokesperson publicly confirming that it has not stopped. The judge immediately identified the gap between what the legal team was telling him and what the administration's spokesperson was telling the public. This happened because of a fundamental disconnect between the political communications operation and the legal team. Leavitt was not thinking about the legal implications of her post. She was thinking about how it would be received by supporters. She wanted to signal that the administration was not actually backing down. In the context of political communication to a supportive audience, that might seem reasonable. In the context of active federal litigation, it was directly damaging to the administration's legal position. She prioritized the political communication over the legal reality. She apparently did not consider that the judge was also a member of the public who would see the post. The coalition of 23 state attorneys general benefited enormously from this situation. In a significant multi-state lawsuit, proving intent and bad faith usually requires extensive discovery, subpoenas, and careful analysis of internal communications. Leavitt's post provided that evidence directly and publicly. The states did not need to build a circumstantial case. The administration's own spokesperson provided the most direct possible evidence of the administration's actual intentions. Every argument the states were making about the administration's approach to the law was confirmed by the administration's own public statement. The judge's use of the phrase distinction without a difference is particularly significant for the administration's prospects on appeal. That is a factual finding based on the administration's own public statement. Appellate courts will review that finding alongside Leavitt's post and the administration's courtroom representations, and the gap between the two will be apparent. This is not a close legal question that turns on technical interpretation. It is a clear factual record created by the administration itself. The practical impact of the freeze and Leavitt's apparent confirmation that it was continuing despite the withdrawal of the memo touches real people and real communities. Road construction projects were stopped. Child care centers that rely on federal block grants faced potential closure. Medical research programs lost funding. Veterans programs were put in uncertainty. This is not an abstract policy disagreement. These are direct effects on people's lives. And Leavitt's attempt to confirm that the freeze was continuing, exposed through her own public statement, reveals a significant disregard for those consequences in the pursuit of a political goal. The irony of this situation from a communications perspective is considerable. The entire purpose of a press secretary is to protect the administration from reputational and legal damage. Leavitt's post did the opposite. Her role is message discipline, yet she publicly contradicted the official legal filing and the position of the attorney of record. The administration's communications team will almost certainly institute much stricter protocols going forward, requiring legal review of any public statement regarding active litigation. When the restraining order is issued, the administration will be required to release the frozen funds immediately. Beyond that, the court's finding of bad faith means the judge is likely to maintain active oversight of the administration's compliance, potentially requiring the administration to file documentation proving that every dollar that was frozen has been properly released. This is an ongoing legal obligation that requires significant administrative resources and that subjects the administration to continued judicial scrutiny.